Hello, my name is Tony Ramos. I am an immigration attorney, and I would like to discuss the most common non-immigrant business visas that we handle and their respective requirements for these visas. A second category of visas we deal with regularly are the L visas. These visas are available to facilitate the transfer of company personnel. These visas are divided into two categories. The L1A visa is for intra-company transferees reserved for executives and managers, and the L1B visa for intra-company transferees reserved for those with specialized knowledge. These two visas are similar in requirements, with the primary difference being the applicant's position as an executive or manager for the L1A and the specialized knowledge of the employee being transferred for the L1B visa. The other L category visa that is available is for the dependents of the L1 visa holders, that is the L2 visa. The L1A visa is reserved for executives and managers of a company that are allowed to be transferred to an affiliated company. The companies have to be related in a certain manner in order to be considered qualifying organizations. Some of the basic requirements are that, number one, the U.S. employer must file the petition on behalf of the employee seeking to transfer the employee from the foreign affiliate. Two, the employee must have worked continuously for at least 1 year for the foreign company within the past 3 years and have worked in either an executive, managerial, or specialized knowledge capacity. Three, the petition must clearly show that there is a qualifying relationship between the U.S. company and the foreign company, including demonstrating that the foreign entity is the parent, branch, affiliate, or subsidiary of the U.S. petitioning company. And four, both the U.S. and the foreign companies must be actively operating. Some of the benefits of being an L visa holder include, one, you can work legally in the U.S. for a U.S. company for a maximum of 7 years in L1A status or 5 years in L1B status, so long as you maintain L1 status qualifications. You can travel in and out of the U.S. freely. And number two, your spouse and dependent children under 21 may enter the United States, and if so desired, your spouse may work in the U.S. If a person is entering the U.S. to open up a new office, then the petitioning company must prove the following. One, secure sufficient physical premises. Two, the beneficiary must meet the 1-year continuous employment requirement. And three, the intended U.S. operation within 1 year will support an executive or managerial position. This includes demonstrating the financial ability of the foreign and U.S. entity to commence business and to compensate the beneficiary. Some of the requirements and benefits of being an L1B visa holder are similar to that of the L1A visa holders. To qualify for the L1B visa, if the employee the employee must possess specialized knowledge of the company's products, service, research, equipment, techniques, management, or other interests, or an advanced level of knowledge of processes and procedures of the company. These visa holders are allowed a total of 5-year period of stay. With these types of business visas, there is a requirement for providing supporting documentation, usually including a business plan and translations of documents that are in a foreign language. Our office has ancillary services to help you create a business plan or to translate your documents. We can also help with establishing a business entity with the respective states. We can help you with these and a host of other services. Please call our office today for a free consultation at 1-956-725-4166 or toll-free if you live outside the United States or even inside the United States at 1-888-878-4727. That is 1-888-US-VISAS. Or you can visit our website at Ramos, that's R-A-M-O-S, immigrationlaw.com. I'm Tony Ramos. Thank you for listening.